So, generative AI is everywhere, right? It's completely transforming how businesses operate. But here's the thing, there's a huge, often invisible compliance gap that could be putting your entire company at risk. Today we're going to dig into why most standard enterprise AI tools are fundamentally non-compliant with GDPR, and what a real solution actually looks like. Look, the promise of AI is massive, we all get that. But as this quote from Shoshana Zuboff highlights, these tools are fundamentally changing how businesses collect, control, and exploit sensitive data. And by rushing to get them deployed, a lot of companies are opening up vulnerabilities that can lead to some really serious privacy violations. And trust me, this isn't just a theoretical threat. It's already causing real-world problems. So what does that look like in the real world? Well, according to a recent Cisco study, get this, a staggering 27% of enterprises have already outright banned generative AI. They've looked at the risk of data breaches and massive GDPR fines and just said, nope, not worth it. This isn't some fringe concern. This is mainstream corporate panic setting in. And just look at who's slamming on the brakes. We're not talking about small companies, we're talking about the absolute titans of finance and tech. Some of the most data-sensitive industries on the entire planet. From Wall Street banks to Silicon Valley giants, the message couldn't be clearer. The current generation of enterprise AI tools just isn't considered safe enough for serious business. Okay, so this brings us right to the core of the problem, the enterprise compliance gap. You see, most companies think they're covered by a simple promise from their AI vendors. But as we're about to find out, that promise has a massive critical flaw. So here's the big assumption that so many data protection officers and IT leaders are working with. They sign up for an enterprise version of a tool like ChatGPT or Claude, and the vendor gives them a guarantee saying, "We won't use your prompts to train our models." Problem solved, right? Well, not so fast. And here is the huge disconnect. The vendor's promise is incredibly narrow, and it's only about model training. But GDPR's requirements, they're incredibly broad. The law doesn't care why you're using the data. If personal data is processed, transmitted, or stored for any reason at all, it has to be protected. The vendor's promise and the actual law are talking about two completely different things. So if that whole no training promise isn't nearly enough, where is the real compliance gap hiding? Well, the answer is actually hiding in plain sight. It's in a place that every single compliance officer already understands perfectly. The GDPR rules that govern how we use public search engines. You know, GDPR doesn't have explicit rules for generative AI just yet, but the precedent for how it treats data sent to a third party for processing is crystal clear. Just think about it for a second. When an employee types any client data into a public tool, it sets off this whole cascade of potential GDPR violations. You've got unlawful data transfers, a complete loss of control over that data, a very real risk of a data breach, and you're violating the core principle of data minimization. The exact same logic applies every time you send a prompt to an external AI model. So what this all boils down to is this. Best practice and legal precedent both say that sensitive client data should never leave your company's secure environment. It's walled garden. But that's precisely what happens every single time someone uses a standard enterprise AI tool. The data leaves your control. And because of that, those tools can never be truly 100% GDPR compliant. And this all points to a fundamental principle that has to guide any compliant AI solution. The walled garden principle. And let me be clear, this isn't just a nice-to-have idea. It's a mandate for data protection by design. And it's baked right into the fabric of GDPR itself. Right at the core of this principle is a key technical requirement: pseudonymization. Now this is GDPR's own definition, straight from Article 4. What it means in plain English is transforming personal data so that it's impossible to link it back to an individual without a separate secret key. It's not just about hiding the data, it's about fundamentally breaking the link. So when you put it all together, there's really only one logical conclusion for compliance. Any personal data has to be fully pseudonymized before it even thinks about leaving your company's walled garden. The AI provider should never ever see the original identifiable data. Period. Okay, so we've laid out the problem. We've talked about the principle. Now, let's talk about the solution. This is AI Vault, a platform that was built from the ground up to solve this fundamental compliance gap once and for all. AI Vault comes at this from a totally different angle. It's an environment as a service. Now, this is absolutely key because it means every client gets their own dedicated secure environment, their own private walled garden that can be hosted on AWS or even deployed directly on-premise. So how does it actually pull off what other enterprise tools can't? Well, the secret sauce is in a unique, patented process that delivers GDPR compliance by design, not as an afterthought. Okay, here's how the magic happens. And remember, this all takes place inside the client's walled garden. First, a user enters a prompt, maybe with some sensitive data in it. Instantly, AI Vault's engine identifies those sensitive terms. Then, and this is the crucial part, it redacts and pseudonymizes that data on-premise before anything gets sent out. Only the safe, anonymized prompt goes for AI processing. And finally, the response comes back to that secure environment where the original data is safely put back in. The AI provider never ever sees the real data. And the result of all this? The third-party AI provider, whether it's OpenAI, Anthropic, or anyone else, is completely blind. They have no idea who the query came from or what the original sensitive data was. It gives you total client anonymity and data security, and it solves that core GDPR problem we've been talking about. Now, this whole compliance by design approach is a complete departure from other security solutions. Those are often very complex, consultative projects that require you to buy separate AI licenses and have really opaque pricing. AI Vault, on the other hand, is designed to be a turnkey solution. It includes the AI licenses you need and has simple, transparent per-seat pricing. No hidden integration costs. So when you actually put it all side by side, the difference is just night and day. AI Vault is really the only solution that was designed from the ground up to be turnkey, transparently priced, and have GDPR compliance built right into its DNA. Ultimately, it gives a compliance officer the one thing they need most: complete control. So I'll leave you with this direct question, especially for every data protection officer and CISO out there. Given the clear precedent for search engine rules and the fundamental need for a walled garden, can you definitively prove that your current enterprise AI solution is GDPR compliant? Because if there's any doubt at all, that risk might just be bigger than you think.